Sparre versus the State of Florida.
May it please the court? I'm Stacy Biggert with CCRC North, and we represent David Kelsey Sparre in his post-conviction case. This is a case about evidence of significant mitigation that never got before this court on direct appeal. It didn't get before this court on direct appeal because Mr. Sparre's appellate attorney failed to make sure a complete record was before this court after Mr. Sparre's trial counsel, twice found deficient by this court in capital cases, failed to take the very simple step of filing the defense sentencing memorandum with the clerk of court. The crux of Mr. Sparre's direct appeal case was a claim under Muhammad versus State, where when a defendant, like Mr. Sparre, waives the presentation of mitigation evidence, the trial court has the discretion, if the trial court is aware of evidence of the probability of significant mitigation, to either call its own witnesses or appoint special counsel to present mitigation to the court.
Is there any question that at least based on the record and the trial court's findings below, that the trial court did have and considered the sentencing memorandum?
Yes, sir. In the order that the court issued, she mentions that she did receive sentencing memorandum from the parties.
Okay. So, and you would agree with me, I think, that the duty under 9.200, I believe it is, to put the record together for appeal to make sure that our court has sufficient evidence to review under Muhammad is the duty of the appellate lawyer, not
Yes,
the
sir.
trial lawyer. So is this really an ineffective assistance of appellate counsel claim rather than ineffective assistance of trial counsel claim?
Yes, sir, and
Okay.
I am arguing primarily the claim in my habeas.
Okay, all right.
But I do think that it goes to note that trial counsel didn't file the memorandum, and I think that is
With the
significant.
with the clerk?
With the clerk, yes.
Okay.
Yes.
All right, so let's focus on the ineffective assistance of appellate counsel.
Yes, sir.
Now, I think I've compared, and I think the briefs do a good job of comparing what's in the proffer that was read into the record that the trial court, or that the appellate court did have, and what was in the sentencing memorandum, which we did not have. They seem to be, at least in substance, pretty similar. How is it so different such that there was prejudice to your client that we didn't understand what the difference was in that mitigation?
Yes, sir. So, in capital sentencing requires individualized sentencing, and details matter. Specifics matter. I asked the court to look specifically at the differences in the information provided about three witnesses: Shannon Bullock, Dr. Greenberg, and Dr. Allgood. Shannon Bullock was Mr. Sparre's counselor at Tiara Hall, where he was, the boys' home where he was when he was a child. Shannon Bullock, as Dave Douglas said at the evidentiary hearing, was the one bright, shining light in this child's life. Shannon Bullock provided, the sentencing memorandums provided much more detail on the testimony that Mr. Bullock would provide about maternal abandonment, parental neglect, details about Mr. Sparre's life at Tiara Hall and what he went through and how his mother left him there and basically didn't see him again for over a year. Dr. Greenberg and Dr. Allgood are not, as Mr. Douglas also said at the evidentiary hearing, they're not defense hired guns. They treated Mr. Sparre when he was a child. And all the sentencing memorandum, all the proffer says about those doctors is they were prepared to testify, they talk about PTSD, and that's pretty much all it says. Dr. Greenberg...
That's a little more than that. It says, and I'm not quoting, but
Yes, sir.
it's summarizing, that there was a lack of treatment he received for his PTSD diagnosis, and that lack of treatment, and that the diagnosis started when he was in a boys' home at the age of 11 through 13.
Right.
That's more than just they're going to talk generally about PTSD.
Right. But in that sentencing memorandum, Dr. Greenberg details the interactions that he had with his family, the profound maternal rejection, paternal abandonment, parental neglect, parental physical and emotional abuse, parental substance abuse, diagnoses of PTSD, not of an adult but of a small child, as well as depression, anxiety, a fear of abandonment, night terrors, and stomach pains and anxiety brought on by trauma. Your Honors, this is the very same type of mitigation that this court found significant in Ellerbe State, and this court granted a new penalty phase. Now, the penalty phase was granted based on Hurst, but it was also granted, and this court made a point of going outside of the Hurst decision to point out that this mitigation, this very same type of mitigation that was in Ellerbe, was significant enough to grant a new penalty phase.
But the difference there is there was a lack of that information at all being presented to the court. Here we have somewhat of presented and then somewhat in more details, and us reviewing not in the penalty phase, but in reviewing should the court in its discretion have entered a new evidentiary hearing. The procedural posture is so very, very different because there's the waiver.
There is a very different procedural posture.
And not only that, but layered on that is the discretion of the court to decide whether it's going to bring in another attorney or standby counsel or have these witnesses testify live or some independent witnesses testify. And that's a pretty discretionary call that the court had at least a lot of information, although not the full basket of information, right?
Right, but I point, Your Honor, to the finding of this court in Mr. Sparre's direct appeal that there's insufficient evidence in the record. And direct appeal counsel
But the
had
court also said in that first sentence that gets left off of the block quote that y'all have in there, that the order was detailed enough for the court to have made the determination, right? Isn't that the first sentence of that very paragraph you just read from?
It is, but
Right.
it also says there's insufficient evidence of the probability of significant mitigation in the record to find that she abused her discretion.
But it said that the order was enough, was independent enough for the court to have made the determination of did the court exercise its discretion appropriately or not, right? Didn't
Right,
we say
yes, sir.
that?
Yes, sir.
How is that not the end of the game? How's that not the end of it? Meaning if the order is detailed enough, and it is here, and it had the proffer, and the court had the proffer, and it had the substance, although not the details of all this information, how is the court not able to exercise its authority under Muhammad appropriately?
The proffer was never meant to be evidence of mitigation before the court, according to Mr. Bate, who testified at the evidentiary hearing. The intention of that proffer was just to facilitate the Kuhn hearing. And whenever he was asked at the evidentiary hearing about why they did nothing to deal with the PCI, which was another issue on direct appeal before this court, their answer was, we intended to present evidence through the sentencing memorandum. So even trial counsel intended for that sentencing memorandum to be additional evidence before the court, and that's evidence that was not before this court when you consider that direct appeal. It is details matter, the significance matters. And if that type of evidence was significant enough to grant a new sentencing phase in a case that had more mitigators than Mr. Sparre's case, then that information should have been before that court for consideration. If there's no further questions on that issue, I would like to move on to one additional issue. As I would like to talk about the guilt phase issues in Mr. Sparre's case. Mr. Sparre's trial strategy was second-degree murder. Despite all of the issues that at evidentiary hearing that were blamed on Mr. Sparre wouldn't let them do certain things. Everyone agreed that Mr. Sparre agreed with their trial strategy. So in opening statements, trial counsel told the jury that they were going to show that Mr. Sparre snapped, and that he was not guilty of first-degree murder, but he was guilty of second-degree murder. Essentially, after opening statement, trial counsel abandoned that strategy. So certain statements from Mr. Sparre that supported their strategy of second-degree murder came in during Mr. Sparre's statement to law enforcement. So that came in on direct. Essentially, all trial counsel had to do was cross-examine one witness, Dr. Giles, the medical examiner. Trial counsel took Dr. Giles' deposition, and during that deposition, he could not rule out that second-degree murder was consistent with the evidence. So essentially, after that deposition, they were in the game. They had a viable trial strategy. Inexplicably, when Dr. Giles testified at trial that it was inconsistent with second-degree murder. Trial counsel didn't cross-examine him on that one statement. That's essentially all they had to do.
Can you point to me where in the motion for post-conviction relief you raise the issue that there was an ineffective assistance counsel for failure to cross-examine as to that statement, cross-examine Dr. Giles?
Your Honor, I don't have a copy of it with me, but it was pled as part of one of the arguments, and it was discussed.
Wasn't it a sentence in support of the actual argument that was made, which was there should have been a consultation with an expert, a counter-expert to Dr. Giles?
Yes, sir, and that is the next step that they should have taken.
But pleading requires much more than that. And here, it wasn't, as I understand it, the deposition of Dr. Giles was never discussed. It was entered into evidence, but it was never questioned by any witness at the post-conviction hearing. This was not argued to the court at any particular point. There was no examination on that portion from counsel, even though you had a full evidentiary hearing on all of these issues. And it only came up in your sentencing memorandum, this issue, which was far too late for the trial court to have dealt with this. It's not addressed in the order. How are we on notice, the trial court on notice, and the state on notice that this is an independent, self-sufficient, and specifically pled claim when it's sort of hidden in plain sight in an otherwise other claim about there should be another expert?
Well, it was in the argument, you're correct, it is in the argument about the independent medical examiner, which is the second part of my ineffective assistance of guilt-phase counsel claim.
And that's clearly pled.
Right, but Your Honor, it was pled in detail in the closing argument, and at the
In the
closing
written
argument,
closing argument afterwards?
after the evidentiary hearing,
So
which we would
it
hope,
wasn't raised as a claim in the post-conviction motion?
it was raised as part of the claim about the independent medical examiner. But it's raised in the closing argument, and I would like to think that
even there is a sentence in the claim regarding failure to call the independent expert. Does it reference that testimony from the deposition?
it does not, but the deposition
Right.
is record evidence. And the claim of failure to
You have to timely file a motion that raises the claims that you want presented to the court to consider, right?
yes, sir, and it
Okay.
was raised in the claim about the medical examiner.
So on the merits, though,
Yeah.
isn't it, the deposition testimony that you're talking about is where Dr. Giles made the comment about saying that he couldn't rule out the possibility that it was, that the wounds were inflicted in a frenzy?
Right.
So, but wasn't the reason, though, for the distinction between the first and second degree was the idea that Mr. Sparre left the room, went and got a knife, and came back? And it's not obvious to me why the frenzy thing, whether it took 2 minutes or 5 minutes or whatever. I mean, can you explain to me why that should be a dispositive issue on the first versus second degree murder
Well, it was their
question?
defense that he snapped and then committed a frenzy. It was their stated defense. It was what they were planning to go forward on. And so whether or not it was committed in a frenzy was their theory that it wasn't second degree murder, and that they failed to even argue that one issue. And so then what we were able to do at the evidentiary hearing was bring in an independent medical examiner, which is the claim that's fully pled, that does discuss that the evidence could be consistent with a frenzy killing. It could be consistent with second degree murder because he didn't have a depraved mind would be second degree murder. So they
How does that
had
create-
this.
Sorry, go ahead.
No, go
Please.
ahead.
No, please. How does that create prejudice? If the and I think you described the testimony accurately. What the independent doctor says is it could have been a frenzy and it could have been 2 minutes or under, I think is what the testimony is. How does that alone create prejudice given the overwhelming evidence on the other side that this was not a frenzy killing, but I think as Justice Muniz described as something between 2 and 5 minutes where he left, got a knife, came back, and slashed this woman 89 or 88 times. I'm not quite clear which one of the two, including multiple defensive wounds, I think 30-something defensive wounds.
Because counsel abandoned their strategy, the jury never heard anything consistent with their defense.
I keep hearing you say they abandoned the strategy, but in closing argument, and I know you take issue with some parts of it, they clearly make arguments about frenzy and lack of intent for first-degree murder. Why is that? It may not have been to what you would have done, may not have been to what the best defense attorneys would have done, but it doesn't seem to me that there was an abandonment. I'm having trouble understanding how there's an abandonment.
Well, the failure to cross-examine Dr. Giles, Failure to call their own expert to do anything to further their defense.
Wasn't that a strategic decision, though?
That's what Mr. Eller said, but
And isn't that what the trial court found?
The trial court found that, and I take issue with that because what Mr. Eller said was, I didn't want them to hear the bad evidence more than once.
Right.
Well, so what happened was they heard the bad evidence anyway, because it was going to come out on the state's direct.
But if the worst evidence against you is how absolutely destructive and terrible this murder was, and you're trying to do everything you can to avoid mentioning that as much as possible, and you have the choice of putting on someone else who's then going to go over the same exact pictures and talk in detail about every single one of the 88 stab wounds that resulted in the murder of this woman, isn't that a reasonable strategic decision to avoid that very thing?
Not if the jury never hears anything consistent with your defense. So to avoid that coming out, you completely avoid doing anything that furthers your defense.
But didn't you say it did? In other words, A, it was argued in opening statement, and B, as you noted, that some of the confessions, some of the statements in the confessions that came in did support a frenzy theory.
But opening statement is not argument. It's just the jury. It's the court. It's the attorney promising the jury
Sure.
what they're going to deliver, but then they didn't deliver it. They
But
didn't do anything
Didn't
to
you know that
further
there?
their strategy.
Didn't you know that there were statements in the confession that did support a frenzy theory?
They were, but then they didn't argue them in closing argument. Instead, in closing argument, they argued that she was a racist and that she cheated on her husband and that she was bipolar.
Didn't the trial court specifically find, contrary to your allegations, counsel did argue closing argument that he snapped, blacked out, was a teenager, and panicked, and cites specifically to pages 1123, 1135, 1144, 1145, 1147, 1148 of the record?
Very briefly, but the remainder of that argument is, and he couldn't say anything about the medical examiner because nothing was ever brought out, but the remaining of that argument was basically trashing the victim. That's what that argument was. It did not reference back and build what Mr. Bate promised in opening that they were going to deliver about a scene of what happened with Mr. Sparre, pull in his statements, how he snapped, and the victim was killed. Instead, essentially that closing argument just demeaned the victim, and that was it.
I don't want to take too much of your rebuttal time.
I'm sorry,
Okay.
Your Honor, may I save the rest for rebuttal, please? Thank you.
May it please the court, Janine Robinson on behalf of the state of Florida. May I address the last subject that was spoken about, the failure to argue second-degree murder as a defense? Mr. Sparre's trial team consisted of 5 very experienced lawyers, over 70 years of experience among them, a team of a total of 12. Their hands were tied behind their back when first their client waived presenting a defense to begin with. Then, in going into the penalty phase, he waived mitigation altogether. And this was not a sudden determination. There's testimony in the evidentiary hearing that Mr. Sparre either spoke to the mitigation specialist or Mr. Bate, who was one of his defense attorneys, that he intended not to put on any family members. He didn't want to get into the mental health issues. He knowingly, intelligently, and voluntarily waived all mitigation. So now when we're moving forward into defense closing and the characterized attack on the victim, this was defense counsel's only means of the very limited facts and evidence they were trying to argue, is he snapped. He was sold a bill of goods by this young woman he met on Craigslist who put herself out as a single woman, wanting companionship, wanting someone to hook up with, for lack of a better description.
I'm sorry to interrupt you, but
Yes.
I mean, do you acknowledge that closing, though, going from sort of one non sequitur criticizing the victim to another, I mean, do you consider that a competent closing argument? I mean, there was no connection between all of the comments about the victim and what the argument was.
No, and the reason I don't is because it wasn't totally non sequiturs. Yes, it's coming out of left field and it's non-traditional, but what the objective was to say the reason that Mr. Sparre snapped, the reason he lost his mind is because after they had consensual sex, took a shower, she then told him, well, I'm married, I'm a mother of 2, and because of his childhood and upbringing, that was the linkage of why he snapped. They had very, very little evidence to argue, and they tried to extrapolate as much as reasonably possible from what was presented at trial. So it wasn't that they were painting the victim as something less than human. It was what she said to him and what she did is what made him snap. If that answers Your Honor's question. I mean, there is a plausible reason, and the trial court found that counsel's testimony at the evidentiary hearing was credible. She understood it. She was also the post-conviction judge is the same trial judge. So she's been here on this case from the beginning. She knows the players, she knows the parties, and she's very well aware of the facts.
Counsel, can I talk about some of the closing arguments?
Yes, sir.
Allegations for ineffective assistance of counsel?
Yes.
Now, step back from you generally. What's appropriate in a response, in a state's response for closing argument in addressing mitigators? So a mitigator is put forward, counsel does their closing argument and puts forward what mitigating evidence they think that is going to be. They file their list. What is counsel for the state permitted to do?
Well, it's easy, for me, it's easier to answer what they're not permitted to do. They're
Sure.
not permitted to denigrate the defense
Right.
by all means.
Right.
And they are entitled to reasonable inferences of what that mitigation showed. And unfortunately, because the record doesn't present that much mitigation, when we go back to the fact that Mr. Sparre.
I understand that, and we'll
Yes.
get there. But going back to denigrating the defense, there were some statements made in closing argument. Let me read them, and let's go over them. Now, the defense is going to argue that the capital felony, that is murder, was committed while the defendant was under the influence of extreme mental or emotional disturbance. Ladies and gentlemen, you determine whether that's a mitigator, number one, whether that's been proven. I guess they're going to argue that he was very emotional because his grandmother was having surgery at the hospital. Think of that. Let me restate that again, that he was very emotional, disturbed, distraught because his grandmother was having surgery at the hospital. So I guess he had no choice but to lash out at this 21-year-old girl that he went to have sex with, and then he decided just to kill her for the heck of it for his enjoyment. Is that a kind of argument that may be denigrating, mitigating, if the mitigator is that he was emotional because his grandmother was in the hospital?
No, the trial judge certainly didn't think so. I mean,
Well, I know what the trial judge didn't think.
yes.
I'm asking you.
And I agree. I agree with the court's determination.
Tell me why that's not denigrating to that mitigator. Again, assuming the jury were to find that mitigator, how is that not denigrating that they're asking for that mitigator?
Because it was a reasonable extrapolation and inference from the facts that were presented during the guilt phase.
That's just a sarcastic question. How is that a reasonable inference from the evidence?
Well, and I shouldn't say this, but I like the phraseology that the trial court used, that while it's dramatic, it's not necessarily inflammatory or improper.
Let me ask you this. What proper basis is there for that argument? So you can't denigrate it. You certainly can say that one aggravator outweighs a mitigator. You can certainly say something's not proven. Mm-hmm. Where does this fit into what is proper?
Other than the prosecutors looking at the facts before him, this was a heavily aggravated event, and all of the conduct by Mr. Sparre, this is an interpretation, and it's a reasonable interpretation. It may, and the judge even acknowledged.
But that's not what he said. What he didn't say was, they're going to argue to you that because his grandmother was in the hospital, he had extreme emotional disturbance. Right. That may be so, but this case is so aggravated because of X, Y, and Z, you should outweigh that versus that. That's a proper argument, right?
Yes.
Okay.
But doesn't necessarily make this improper. Plus, the jury was properly instructed on the emotional disturbance mitigator. So the jury could not have been confused after they were properly instructed.
All right, let's talk about a little further down with regard to impairment. He was so impaired that I guess he stabbed her 89 times. Is that what their argument is going to be? That if he hadn't been impaired, then he might have stabbed her 150 times? He might have enjoyed the murder more? He might have made her suffer more?
Again, it's a very dramatic characterization of these are facts that were before the jury. I mean, 89 times, 39 stab wounds.
Well,
and
I understand those facts were
Yes,
150 wasn't in, and what
No.
the effective impairment would have been. What they argued as a mitigator is that he was impaired. Now, again, that might have been proven or not proven. That's not the point. But the question is that denigrating them asking for an impairment defense because you're saying if he wasn't impaired, he would have stabbed her more times?
It's very, I cannot concede that it's denigrating. Is it extremely dramatic? Yes. Now, whether it is improper and does it undermine the confidence of the conviction and sentences case? I don't believe it reaches that level.
Well, that goes to prejudice. I'm not
Yes,
asking about that,
okay.
and we'll talk about that.
Okay.
But you're telling me that these arguments are consistent with our case law on denigration of mitigators?
Yes, sir.
Okay. Tell me why it's not prejudicial, assuming I disagree with you.
Yes, sir. These statements, and there are a number of them in counsel's brief that she points out, when they are read in context and there are statements before and after these cherry-picked statements, that it goes back to either establishing premeditation or arguing against defense counsel's second-degree murder defense. They are reasonable interpretations of the facts that were presented through Dr. Giles and through the detectives. Also through the defendant's own statements that were recorded with law enforcement. So these are all extrapolations and reasonable inferences taken from the evidence that was before the jury. And the bottom line is, not individually or together are they so inflammatory that they were going to undermine either the conviction, which was unanimous, or the sentencing recommendation. And at the end of the day, the jury was properly instructed. There were no questions about that, so there can't be any confusion or improper pleas to the jury's emotional, heartstrings. And I will stop right there. That's a whole little laundry list of why it's not prejudicial. Does that answer sufficiently?
Thank you, counsel.
Okay. I want to go to the sentencing memorandum. Justice Luck, you echoed what I was arguing. The bottom line is the trial court had the sentencing memorandum, and as far as ineffectiveness of whether trial counsel did not file it, the record's unclear. We don't know what happened. Is it reasonable to suggest? Yes. Could it have been the clerk? Yes. The simple fact is we don't know. Be that as it may. The bottom line is the trial court had the sentencing memorandum. The trial court had counsel's notice of mitigators, which was very detailed as well. Her sentencing order explicitly says she took into consideration the sentencing order, everything that was presented at trial. And as the court has seen, it's a very detailed and comprehensive sentencing order. The difference between the proffer at mitigation waiver and the actual memorandum, the differences are not material. The court had enough information available to her to write a sound, well thought out, thorough order. Let's see. Are there any questions on that issue? No, okay. Since those seem to be the main issues, the state would rely on our briefs and ask this court to affirm the trial court's order and reject any habeas petition relief. Thank you.
Quantity of lawyers is not as important as quality of lawyers. This was argued in the judge's order. It's been argued by the state. Mr. Sparre had 5 lawyers, therefore it's competent. Mr. Sparre had 1 death-qualified lawyer who cannot take capital cases anymore. He had 4 additional lawyers who all jumped on his case so they could get death qualified. There was confusion at the evidentiary hearing over who was actually lead, who was 4th chair, who was 3rd chair. This was not a well-oiled machine. 5 lawyers, yes, but that was not quality representation. I also take issue with the idea that everybody knew all along that Mr. Sparre was always going to waive. That was something else that was very confusing at the evidentiary hearing. In fact, Mr. Arnold and Mr. Eller, who were the 2 attorneys in charge of presenting the mitigation, Mr. Arnold said that he was shocked when he waived at the beginning of the penalty phase.
But the trial court found against you on that, and there was competent substantial evidence from one of the counsel who said that he knew from at least some significant months before that the intention was always to waive mitigation, and they were trying to talk him out of it, right?
That's what the court said, but the lead trial counsel said that he was...
Wasn't there one of the attorneys who testified to those exact facts?
There was 1 of 4, yes, sir. There was 1 of 4.
How do we review those findings if there's evidence in support of it?
Because there's evidence against it. The lead trial attorney said he didn't find out till the day before. So, I mean, the court also finds the lead trial attorney credible on other issues. So, credible on some, credible on none. I mean, the problem is you have confusion among the attorneys about what he was going to do. Also, you know, Your Honor, Mr. Sparre never, the Attorney General said that he refused to let them put on a defense. That is also not true. It was clear at the evidentiary hearing that he agreed to go forward on a defense of second-degree murder, and he let them put on their defense. No one ever
Did he
testified.
refuse to allow them to call any witnesses, and he,
That was really unclear, whether or not that they refused to let him call any witnesses. It was never testified that they would not allow him to hire a defense expert. That was never testified to at the evidentiary hearing. So he was allowing them to put forward a defense of second-degree murder. And he allowed Mr. Pate to give the
but
roadmap that he
you don't
gave.
allege, whether he allowed them or not, you don't allege that they should have called additional witnesses to flesh out the theory of defense other than the one expert.
No, sir.
Right.
No, sir, I do not. And finally, substantially the same is not enough. In individualized sentencing, the details matter, the specifics matter, and the information in that sentencing memorandum matters. Your Honor, I ask this court to please either grant Mr. Sparre a new direct appeal under the habeas petition or grant him a new trial. Thank you very much.
We thank you for your arguments. The court is now in recess.
All rise.